All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So today I want to talk about three recent developments here, and they're all sort of tied into things that we've been chatting about on the program for quite a while. So the first is that there's a circuit court rift forming on deference to the National Labor Relations Board. And of course, this relates to a topic we've covered in quite a bit of detail on the program, the Looper Bright Enterprises case that did away with the Chevron deference standard. Of course, we had our friend and colleague Jim Plunkett from Ogletree's Washington, D.C. office on to talk about this significant development. And what appears to be happening in light of Looper Bright is that some of the federal appeals courts are really beginning to diverge on how the end of the Chevron doctrine will impact judicial review of National Labor Relations Board decisions moving forward, whether they're going to continue to defer to the board or not. Last week, the U.S. Court of Appeals for the Sixth Circuit broke with 5 other circuits, and they cited Looper Bright in doing so, saying that it doesn't yield to the NLRB's readings of the National Labor Relations Act. So I, of course, our listeners here in Missouri, we're in the 8th Circuit. Justin and our listeners over in Indiana and in Illinois are in the 7th Circuit. That's the circuit where I used to work when I got out of law school for a federal district judge. And then on the other side of Justin's state, there is the 6th Circuit, covering several of the states backing up to the other side of Indiana there. And so the 6th Circuit basically said that it's not going to necessarily defer to the NLRB's interpretations of the National Labor Relations Act. And so one of the things that, of course, the NLRA does is it gives litigants that lose at the NLRB an opportunity to seek judicial review in the court system. And basically, the NLRB cannot enforce its own orders. And so the NLRB sometimes has to go into court to force or enforce its orders. And failing to comply with the court's ruling enforcing a board order could be punishable not only by civil penalties, but even jail time, which is unusual, but does from time to time happen. So it hasn't been really a question of if, but when there would be a split in the circuits developing on this issue of deferral to the NLRB. And basically, the NLRB has been around for about 90 years, and the board has been interpreting and fleshing out a relatively bare bones law, the National Labor Relations Act, in the course of policing workers' organizing rights. And one legal professor said that the NLRA is written more like the 10 Commandments than the Federal Register, which means that the law itself is, like he said, kind of bare bones. So Looper Bright, of course, doing away with Chevron deference definitely is going to have an effect when the NLRB is challenged on its rulemaking, challenged on its flip-flopping that we've talked about from one presidential administration to the next, and is also when it's challenged on its newer expansions of its interpretations of the statute. And that's what we're seeing taking place. And so I really raised this case just to remind people that there is a split in the circuits developing. We're likely going to get some appellate court decisions ruling, continuing to develop this split, and some of this may end up back at the U.S. Supreme Court at some point. All right, so I want to move on to the next topic here, and this one is pretty significant. U.S. payrolls were reduced or marked down by the most since 2009 in preliminary data. The number of workers on payrolls is likely going to be revised down by more than 800,000 jobs for the 12 months through March, or around 68,000 fewer jobs per month, according to the Bureau of Labor Statistics preliminary benchmark revision. And again, this is the largest downward revision since 2009. And economists did expect a decline. Some had predicted a decline of up to 1 million jobs, but the figure looks like it's going to be north of 800,000. And what this does is it suggests something that Phil and I've been talking about quite a bit on the program with some of our other guests, and that is that the labor market started moderating much sooner than originally reported. It really wasn't until earlier this month that markets and economists started to grow concerned with the release of the July job reports, and that set off alarm bells with a weak pace of hiring and a fourth month of rising unemployment. And one of the things that we've been talking about quite a bit on the program is that while there are a lot of job openings and people still hiring in certain segments of the economy, we're also kind of on the front lines here at Ogletree doing reductions in force for clients. And we've been seeing these reductions in force taking place really for the last 2 years. And a lot of these reductions in force are in the tech industry and a lot of other white collar jobs. And that's where most of these jobs are coming from. That this downward hiring figure is coming from. It really is largely in the white collar sector. And so, again, I think this just reminds us that we are in a really interesting time, a really interesting job market here. And of course, these figures are being cited in anticipation of the Fed perhaps reducing the federal interest rate coming up here in September. Some people are expecting a 0.25 cut in the interest rate, and others are expecting maybe as much as a 0.5 point cut in the interest rate. So it'll be interesting to see what happens next month. I think that most traders, the treasuries have edged higher after the data reinforced these wagers that the Fed will start cutting rates next month, and traders are expecting really, again, that 0.25 point cut next month, and they're assigning a roughly 20% chance for a 0.5 point reduction. So take that for what it's worth. All right, now shifting gears, I want to talk about one more case here, and that is a case also related to the National Labor Relations Board. And this one, in this particular case, workers at a Birmingham bar were not protected by federal labor law when they participated in Black Lives Matter protests against racial discrimination. And this ruling is actually from the National Labor Board itself. The employer in that case, the Parkside Cafe, basically it terminated some employees when the employees' activity in the Black Lives Matter demonstrations outside of work was not aimed at improving their terms and conditions of employment. The NLRB just issued this decision yesterday. Now, remember, the NLRB back in February ruled that Home Depot had to reinstate a worker who was effectively fired for refusing to remove the Black Lives Matter insignia from their work apron. But the board's Home Depot decision declined to hold that protesting civil rights issues on the job is inherently protected by the National Labor Relations Act. So this Wednesday ruling, again, really stemmed from these allegations that the Parkside Cafe constructively discharged 3 workers for participating in the Black Lives Matter protests. In this case, the judge, the administrative law judge at the NLRB, dismissed the charges, finding that there were no connections between the protests in this case and any concerns about racial injustice at the workplace or at any other particular employer. And so that's the key there, is that protesting and general social justice activity in and of itself is not inherently protected in the workplace. The employees who are engaging in this activity, if they want their conduct to be protected in the workplace, they have to somehow tie it to their terms and conditions of employment itself. It's a very fine line there. And of course, what I would say is that any employer who has concerns about whether or not an employee's social justice activities sort of roll over into the workplace and might be protected should reach out and definitely seek some legal guidance on that.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.